They built a fortress of marble and lies, where justice fades and hope just dies. 1,000 doors they slam in your face. The giants laugh, they own this space. Multiple bites on the apple they take. The system bends, it starts to break. Filing papers, burning dreams down the rabbit hole, or so it seems. The P-tab moves like a clock with no hands, lost in the maze, nobody understands.
Welcome to this episode of the Patent Litigation Podcast. Today I, along with Dr. Angela Liu, will be discussing the IOENGINE case in which the Federal Circuit institutionalized giving accused infringers multiple bites at invalidating patents. As always, the views and opinions expressed in this podcast do not necessarily represent those of Brown Rudnick. This podcast is presented for informational and educational purposes only. Thanks for joining me again, Angela.
Great to be here, Eric.
All right, let's dive into why this IOENGINE case has everyone in the patent world buzzing. On one hand, we're talking about a fairly typical patent dispute over portable electronics. U.S.C. devices with processors essentially acting as a bridge between a terminal and a server. But, on the other hand, the implications, they could reshape how patent owners defend their claims moving forward.
Exactly. And at the center of it, you've got Ingenico, PayPal's supplier, who didn't just file an IPR challenge, but also took it to district court, broadening those invalidity arguments, which honestly isn't surprising. It's smart even, but it's also disruptive for patent owners trying to keep up with these multiple challenges.
Right. What's disruptive is the Federal Circuit's interpretation of estoppel under 35 U.S.C. paragraph 315E, 2. It upheld invalidity claims based on prior art, get this, that Ingenico conveniently didn't bring up during the IPR. That's a major distinction here.
It really is. I mean, the very purpose of IPR estoppel was to give patent owners some protection after enduring IPR challenges. You know, that sense of, finality. But this decision kind of pulls the rug out from under that. It allows for another attack in court as long as the argument falls outside what could reasonably be raised during the IPR itself.
Right, and it hinges on how the court defines grounds of invalidity. By limiting estoppel to patents or publications as prior art in the IPR context, the Federal Circuit opens the door on arguments tied to public use, sales, or even knowledge of the prior art, areas traditionally tackled in district court.
I think that artificial separation between printed publications in an IPR and real-world evidence in court is what makes this decision so concerning for patent owners. You're potentially facing a 1-2 punch. First IPR, then district court. Same prior art package, just dressed up in a different statutory outfit.
It's frustrating, absolutely. And it kind of, undermines the whole intent behind the America Invents Act. Congress wanted to streamline disputes, make things efficient, but now patent owners have to defend against duplicative challenges, which raises costs and complexity.
100%. And smaller patent owners, they're probably the most vulnerable here. How do you defend a patent when the game keeps shifting between forums? It's expensive, it's exhausting, and it feels like the scales tilt toward infringers in this scenario.
Yeah, it does. And looking at the big picture, this interpretation weakens protections that were supposed to shield patent owners, from over-litigation. The unintended consequence is patent rights now feel just a little more, let's say, fragile. So, now let's take a closer look at the specific case driving all this concern, IOENGINE. They held two patents, 9059-969 and 9774703 for technology in portable devices, like USB drives that enable communication between terminals and network servers. Ingenico, PayPal's supplier, went on the offensive here, first filing a declaratory judgment action, and then stacking it with IPR petitions, testing every possible angle to invalidate those patents.
Yeah, and let's not forget that the Patent Trial and Appeal Board, or PTAB, sided with Ingenico during the IPR, invalidating most of the challenged claims. But Ingenico didn't stop there. In parallel, they went to district court and introduced evidence of the disk-on-key device.
Oh, the disk-on-key. Now that's interesting backstory. It's this early 2000s USB device from M Systems loaded with software like the firmware upgrader and other tools that acted as the linchpin in Ingenico's argument. They claimed...
Wait, let me guess. They argued that the disk-on-key essentially anticipated or made IOENGINE's patents obvious, right?
Exactly. They pushed that it was on sale, in public use, or known and used even before IOENGINE's invention date. And this was key, using arguments that, well, could have been brought up during the IPR proceedings, but apparently weren't.
Right, and IOENGINE wasn't having it. They argued Ingenico should have been stopped from relying on the firmware upgrader under 35 U.S.C. Sector 315E2. Essentially saying Ingenico had their shot to raise these points during IPR, so they couldn't weaponize them now in court.
And yet, and here's the rub, the district court disagreed. They ruled that Ingenico didn't have to leave those arguments behind. The jury eventually sided with them, finding IOENGINE's claims invalid. IOENGINE appealed, of course, but the Federal Circuit's interpretation of IPR estoppel sealed their loss.
Sealed is right. The court narrowed the scope of what estoppel could apply to by saying it only precludes patents or printed publications, not things like public use or the kind of real-world evidence Ingenico brought up.
That's the bone of contention here. By parsing grounds this way, the court effectively lets petitioners have that second bite at the apple in district court, even with overlapping prior art. And honestly, it raises some significant concerns for patent owners.
It does. Theoretically, you're never really done defending your patent if the prior art challenges can just keep shifting formats. I actually had a case like this.
Oh, do tell.
Well, there was this software tool claimed in a patent, and during IPR, the petitioner hammered us with patents and articles. We held strong there, but afterward, they turned around and started pulling public demonstration arguments in district court. Things they could have, easily dug up during IPR. And I'll be honest, it made everything feel like a never-ending game of guess their strategy.
You're not alone in that frustration. Cases like Ingenico just exacerbate this imbalance. And for smaller patent owners, especially,
they're caught in the crossfire of escalating costs and, constant uncertainty.
Couldn't have said it better myself. And that's exactly where the Federal Circuit's deep dive into the interpretation of grounds under the IPR estoppel statute, 35 U.S.C. Parv 315E2 becomes so pivotal. Estoppel was supposed to be a safeguard, shutting the door on invalidity arguments that petitioners could have used during IPR. But instead, with this decision, the court has left that door ajar, effectively giving petitioners new ways to keep circling back with fresh arguments.
Right. They focused on what ground means and decided it covers only invalidity theories involving patents and printed publications like prior art you'd find in a database or journal. But get this, they completely excluded other invalidity arguments like public use or sales that couldn't be raised in an IPR. That's a huge loophole.
It really is. And in the Ingenico case, that loophole was everything. Remember how Ingenico brought up the disk-on-key system? It wouldn't have mattered if there were printed publications on that technology in the IPR, because Ingenico pivoted to public use arguments in district court. And the court, they gave it a thumbs up.
Exactly. Essentially, they argued, this device was out there, people could have used it, it was on sale. And bam, IOENGINE's claims were in trouble all over again. I mean, it feels like a classic bait and switch for patent owners.
Yeah, especially when you consider how Congress designed IPR proceedings. The whole point was to streamline patent disputes, not stretch them into marathon battles. But this decision, it's like the Federal Circuit took that intent and said, well, not so fast.
Right. It's one thing to defend a patent during an IPR, But to then have to brace for similar invalidity challenges under a different disguise, in court, that's exhausting, not to mention expensive.
And here's the kicker. This isn't just about IOENGINE. This affects anyone holding a patent, big or small. Because now there's this clear, maybe even deliberate separation between printed publications in IPR and real-world evidence in court. It's, I don't know, borderline artificial, wouldn't you say?
Absolutely, and yet, courts seem to be okay with giving petitioners a second bite at the apple.
Or a third.
Good point. You're never really done defending your patent. It's like playing defense in two very different games with two very different sets of rules. For smaller patent owners, all this shifting just makes it harder to hold their ground.
And looking at costs alone, it's staggering. You've got to prepare for an IPR, and then you've got to double down for district court. It's a strategy that, frankly, seems to favor whoever has the deeper pockets.
Yep, and with this interpretation of IPR estoppel, the Federal Circuit has handed accused infringers a pretty nifty playbook, one that patent owners are going to have a tough time countering.
So after all that, we have to step back and consider the larger implications. The PTOB was originally supposed to be this efficient alternative for handling patent disputes. Faster, cheaper, simpler. But with decisions like this, is it really achieving any of that? If anything, it's starting to feel like it's adding to the confusion and costs instead.
Not at all. If anything, it's creating more opportunities for accused infringers, especially bigger players with deep pockets, to essentially wear patent owners down through multiple rounds of challenges.
Exactly. Instead of a streamlined process, we're seeing a scenario where infringers can essentially attack from every angle. First through IPR, then turning around and raising different invalidity arguments in district court. It's like giving them, 2 or 3 bites at the apple?
It's exhausting just thinking about it, and here's the thing, it's not just the big companies that benefit from this. They're the ones taking advantage of these loopholes to make it harder for smaller inventors or startups to enforce their patents. And the cost? It's astronomical for the patent owners trying to fend this off.
That's the real kicker, isn't it? The America Invents Act positioned IPR as a way to reduce costs and bring efficiency to patent disputes. But instead it's become another avenue for leveraging power imbalances. It's the smaller patent owners who end up footing the bill, literally and figuratively.
It feels like the scales are really tilted here. These decisions don't just raise costs, they increase complexity. Patent owners now have to prepare for multiple layers of litigation and for arguments that could have or should have been raised during the IPR process. It's like fighting a hydra. Cut off one head and 2 more pop up in court.
Right, and this isn't just a theoretical problem. When you look at world innovation rankings, the U.S. is starting to slip behind. And some of that comes down to how we're handling patents. Decisions like this one don't incentivize invention, they discourage it. Smaller players who are often drive innovation are left wondering if taking the patent route is even worth it anymore.
Exactly. If you're a startup or an individual inventor, how do you even compete with the big players who can litigate issues from every possible angle? They've got the resources to keep these fights going indefinitely. And these small inventors, they're burning through their resources just to stay in the game.
And zooming out, it's no surprise that countries like China are pulling ahead in core technologies. They're fostering innovation while we're bogged down in endless litigation. This isn't about protecting inventors anymore. It's about creating more opportunities for big tech to dominate the playing field.
And honestly, it's frustrating. The IPR process, in theory, had some noble goals: efficiency, cost savings, and more certainty. But when you see these results, a fractured system that seems to reward infringers over innovators, it's hard not to feel like we missed the mark somewhere.
Miss the mark is putting it lightly, and the ramifications, they're stretching far beyond this one case. Patent owners aren't just defending their rights, they're fighting an uphill battle in a system that honestly doesn't feel designed to properly protect them. Building on that uphill battle, one of the key issues patent owners are now grappling with is the narrowing of IPR estoppel protection. This ruling essentially opens the door for infringers to challenge patents on one set of grounds during IPR, and then pivot to a completely different set of grounds in district court. It's the judicial equivalent of an end run.
Exactly, and it creates this unfair double standard. Patent owners expect IPR estoppel to give them some finality, like once you've defended your patent in one venue, that's it. But no, this decision weakens that protection. Now, instead of estoppel being a shield, it feels more like a sponge with holes all over it.
Good analogy. And speaking of holes, let's talk about the second issue. The artificial distinction the court draws between printed publications and, other types of evidence like public use or sales. It's the same prior art, Angela, just wearing a different disguise.
Right, it's purely semantics. Take the disc-on-key system. One day it's argued as a publication in an IPR. Then later it's brought up again in district court as, oh, look, public use evidence. Same tech, different hat, and it forces patent owners to defend the same territory, not once, but twice.
Exactly. When patent law gets reduced to which hat is the art wearing today, there's a fundamental problem. And that brings us to the third concern, the evidentiary standard for public use. It's practically an open invitation for circumstantial evidence to carry the day.
Right, and here's what bugs me. In the Ingenico case, all they had to show for public use were things like, oh, employees encouraged customers to download this software, or customers might have had access to firmware documentation. No solid proof anyone actually did these things.
But apparently enough circumstantial evidence that the court just ran with it.
Exactly, and for patent owners that's terrifying. A jury can invalidate a patent based on maybe someone used it, rather than hard evidence. It flips the burden of proof upside down.
And it doesn't stop there. Let's talk about the fourth concern, the sheer increase in litigation complexity and cost. Smaller patent owners, well, they're absolutely getting crushed here.
Right, they're not just fighting in one court, they're fighting on two fronts, the PTAB and district court. It's not just expensive, it's exhausting. And these bigger infringers know it. They drag smaller inventors through the mud until they just give up.
And that's where we hit concern number 5, how this decision undermines the very intent of the America Invents Act. IPR was supposed to simplify patent challenges, right? Streamline disputes, but now it's ballooned into this two-stage battle royale.
Yep. Instead of clarity, patent owners get chaos. The irony is so thick it's painful. We're making it harder for the people who actually innovate to protect their work. Eric, if someone told me the AIA was meant to protect infringers instead of inventors, I'd almost believe them.
You might be onto something there. Angela, with everything we've just outlined, it's clear that patent owners can't afford to leave anything to chance. Navigating these challenges demands more than just resilience. It takes deliberate strategy. Take comprehensive prior art searches, for example. This is not just a recommendation, it's a necessity. You'd agree, wouldn't you?
Absolutely. You have to know what's out there, including things like on-sale products or public uses that might not show up in databases. It's not just about publications. A wide net catches more potential threats, and frankly, saves headaches down the line.
Right. And speaking of planning ahead, choosing the right forum for enforcement matters now more than ever. With IPR no longer the final word, you really have to consider whether district court's the better starting point. Thoughts?
Yeah, if you've got potential evidence that extends beyond patents and printed publications, skipping IPR could make sense. It's kind of a trade-off. You lose the benefits of the streamlined IPR process, but you're less vulnerable to this double whammy.
Exactly. And let's say you do find yourself in district court. Your responses to invalidity challenges need to be airtight. We're talking robust defenses to address things like public use claims. Think secondary considerations, strong expert testimony, the works.
And don't forget to scrutinize the evidence being presented by the other side. Is it circumstantial? Weak? Don't let them slide into a win on a technicality. Push back hard.
Strong pushback, yes, which actually ties into another key point, claim drafting. Patent prosecution isn't just about securing approvals. It's about crafting claims tailored to withstand these shifting arguments. Narrow but precise claims can make a world of difference.
Exactly. And don't be afraid to pursue continuation applications. Keeping your options open lets you adapt to competitive threats as they evolve. Flexibility is a huge advantage when the playing field keeps shifting.
Adaptability is critical, no doubt. And speaking of preparation, documentary evidence, especially for pre-AIA patents, is pure gold. Proving conception dates, reduction to practice, it's foundational when fighting off challenges based on public use or sales.
Right. Strong documentation builds your defense. But Eric, this last one's a bigger picture issue, legislative advocacy. Is it time for the patent community to push for tighter IPR estoppel rules?
Definitely. The intention behind IPR was good. Efficiency, reducing litigation. But the application, it's clear as mud. A legislative fix could help restore balance. Without it, we're leaving patent owners stuck in an endless defense cycle.
And unless there's advocacy from patent owners and practitioners, nothing's going to change. It's time to push for laws that close those loopholes and frankly make estoppel mean something again.
Couldn't agree more. In the meantime, though, it's all about preparation, adaptability, and playing smart. You can't control the framework, but you can control how you navigate within it. Speaking of navigating within the system, a recent Federal Circuit decision has really highlighted how circumstantial evidence is being used to establish public use. This kind of shift is giving patent owners plenty to think about. It's definitely shaking things up.
For sure, the court essentially said, hey, circumstantial evidence is good enough, but that doesn't sit well if you're the one defending a patent, does it?
Not at all. They took what seemed to be a fairly abstract set of facts and ruled that it was substantial enough for a jury to conclude there was public use. Case in point, the disk-on key device. The evidence presented? Employees encouraging customers to download the firmware upgrader or offering access to a guide. But
Right, but nothing concrete, nothing that definitively proved anyone downloaded or used it before the critical date. And still the court was like, close enough, that's a heavy blow for patent owners.
exactly. It lowers the bar. Now, instead of needing clear documentation or direct proof, someone can just string together a narrative based on circumstantial hints. If this is the new normal, invalidating a patent suddenly feels, well, way too easy.
Totally. And the thing is, most of this so-called evidence wasn't even public-facing. A user guide being accessible or employees saying, hey, this exists, it doesn't scream public use. But the court still used it to invalidate IOENGINE's patents.
And that, Angela, is what irks so many patent owners. With such a low evidentiary burden, infringers gain a huge advantage. Suddenly, any vague references to prior use could become grounds for invalidation, even if the alleged prior art wasn't widely available or especially documented.
And for smaller players, that's devastating. How do you prepare for a challenge built around maybe could have scenarios? It turns into this unfair guessing game. You spend resources defending against hypotheticals.
Exactly, and let's not miss the bigger picture. This undermines predictability in the system. If circumstantial evidence can carry this much weight, patent enforcement starts to feel like walking on quicksand, constantly shifting and never stable.
That's a great metaphor. It's quicksand. And not the fun metaphorical kind from movies, but the kind that sucks innovation out of the system. Honestly, this decision just adds one more thing to the growing list of challenges patent owners are up against.
With challenges like these, patent owners are left asking, what can we do to adapt? The first step has to be thinking long-term and strategically. A clear example? Comprehensive prior art searches. And I mean going beyond just skimming databases for patents or publications. It's about looking at the bigger picture.
Exactly. We're talking about going beyond the obvious, right? You've got to dig into potential on-sale products or public uses, things that aren't going to show up in your standard prior art databases. It's a broader search, but one that can save you from nasty surprises later on.
Right, because without that foundation, you're walking into enforcement blind. And strategic forum selection is another big one. Some patent owners might want to skip IPR altogether if they anticipate arguments based on public use or sales outside its scope. Cost versus control,
Totally, it's all about knowing your risks. If an IPR isn't going to give you real finality, which we've seen now with cases like Ingenico, you might actually find yourself better protected by filing in district court first. It's a trade-off, but it could save you from that 1-2 punch later.
Exactly. And listen, when you do end up in district court, patent owners need to bring their A game. Your defense against invalidity challenges has to be airtight. Public use arguments, you'd better be armed with secondary considerations and expert testimony that can pick apart their case.
And don't underestimate the importance of punching holes in circumstantial evidence. If the other side's barely scraping together a narrative, call it out. Weak arguments should never be allowed to gain traction just because they sound plausible.
Absolutely. Now let's talk prosecution strategy. Crafting claims with these potential challenges in mind has never been more important. Tailored claims, narrow enough to distinguish your invention while being broad enough to bite, are worth their weight in gold.
And stay flexible. Use continuation applications to keep your options open. A good portfolio protects not just your initial invention, but also adapts to competitive threats as they emerge. It's about playing offense and defense at the same time.
Right, and let's not forget one more foundational piece, documentation. Those pre-AIA patents, you want rock-solid evidence of conception and reduction to practice to fend off public use or on-sale claims. Sometimes the best defense is just being better prepared.
So true. And Eric, big picture here, this is where legislative advocacy has to come into play. The patent community needs IPR estoppel rules that actually mean something and close these loopholes. Without that, we're just stuck patching leaks with duct tape.
No question about it. But until then, preparation and adaptability are critical. You mitigate risks one step at a time and control what you can. Let's face it, the framework's broken, but navigating it, that's where smart strategies win. Building on the need for preparation and adaptability in this landscape, let's dive into how this decision has shifted the balance on the burden of proof. Traditionally, invalidating a patent required clear, convincing evidence, setting a high standard, as it should be. But now, with this lower evidentiary threshold, that principle is, well, it's eroding, and it's changing the way we approach enforcement and defense strategies.
Completely agree. The court's acceptance of circumstantial evidence as enough to prove public use, it feels like an exception swallowing the rule. And for patent owners, it's unsettling. I mean, we're talking about a situation where maybe it happened turns into that's good enough to invalidate.
Exactly, and the implications are staggering. The Ingenico case highlights this. Public use in this context was inferred from things like customers having access to guides or being encouraged to download software. Not direct evidence, nothing concrete, yet it worked.
And that's the scary part. If you're defending your patent, how do you fight off what amounts to educated guesses? They didn't need solid proof that someone actually used the disc-on key system before the filing date, just breadcrumbs. And the court said, sure, close enough.
Right. And that sets a dangerous precedent. It shifts the burden in practice, even if not on paper. Patent owners are now essentially forced to disprove these vague public use claims. It flips the system on its head.
Not to mention the cost. Fighting off these challenges drains resources, especially for smaller players who can't throw money at every little lawsuit. It's exhausting and unfairly tilts the scales toward the big guys.
Yeah, and it's not just smaller players who lose out. The predictability? Gone. The whole basis of the burden of proof is to create certainty. And when you loosen the evidentiary standard, you end up with a system that's anything but predictable.
Totally. It's like you're always on edge waiting for what twist comes next. For patent owners, this kind of uncertainty isn't just frustrating, it's debilitating.
And longer term, it discourages innovation. Why risk time, effort, and capital enforcing patents when the framework to protect them feels like shifting sand? This decision amplifies those fears, makes patent rights feel fundamentally less stable.
Exactly, and I'll say this. If circumstantial evidence becomes the new norm at this level, patent owners are going to have to rethink everything about how they approach both prosecution and litigation strategies.
You know, Angela, all of this unpredictability and the challenge it brings to patent enforcement makes me think about another critical issue. IPR estoppel, especially in situations like the Ingenico case. This Federal Circuit decision underscores just how intricate and, at times, frustratingly opaque the process can be for patent owners trying to stay ahead.
Absolutely, Eric. At its core, this decision forces patent owners to rethink not only their litigation strategies, but their entire approach to protecting innovation. The days of relying solely on IPR for finality appear to be behind us. And honestly, that's a tough pill to swallow when the system was designed to simplify things.
No question about that. The unintended consequence here is a system that feels rigged against innovation. Instead of being able to focus on creating and securing patents, owners are now bracing for multi-front battles that seem, well, never-ending.
And it's not just about cost, although that's a huge factor. It's the unpredictability, isn't it? You think you've dotted your I's and crossed your T's, only for the finish line to move once you get to court. I think this decision makes it clear that adaptability isn't just a recommendation anymore, it's a requirement.
Completely agree. And the bigger picture here, it's not just patent owners feeling the pressure. The ripple effects of decisions like this discourage smaller innovators, the people who really drive progress, from even entering the system. What's to gain if the protections feel so fragile?
Exactly. If we want to keep the U.S. at the forefront of innovation, we need clarity in patent law and real protections for inventors. That means everything from rethinking strategies like robust prior art searches and defensive litigation tactics to broader legislative fixes.
And those fixes, they're going to need a push from the entire patent community. Advocacy matters. For now, though, patent owners have to focus on what we can control. Preparation, flexibility, and sharpening the tools we already have. The framework might feel broken, but playing smart within it, that's still in our hands.
Couldn't have said it better. For all the challenges, there's still room to innovate and protect those innovations. With the right strategies and a united approach, patent owners can adapt even to this kind of shifting landscape.
And on that note, Angela, it's been great discussing this with you. Thanks for bringing your insights and, as always, your energy to the table.
The pleasure's all mine, Eric. It's always a pleasure to break these things down with you. And to our listeners, thanks for tuning in to another episode of the Patent Litigation Podcast.
Until next time, stay curious and keep innovating. Take care, everyone.
The P-tab moves like a clock with no hands. Lost in the maze, nobody understands. Efficient whispers, but they shout decay. The truth drowned out, it fades away. Multiple bites on the apple they take. The system tilts, we can't catch a break. Rules rewritten, mistakes are sly, climbing uphill just to kiss the sky.